Hello, I'm here to talk to you today about why someone should or would want to create an estate plan. Let's start with, what is estate planning? Many people think, and correctly so, that estate planning deals with the transfer of assets on death. But estate planning is actually much more than that. Estate planning addresses incapacity, meaning when you are unable to make your own decisions. This can happen with age or an accident. You can choose how and who will manage your personal care decisions and your healthcare decisions. Things like where you will live and what medical care you will receive. Estate planning can also address who you would like to take care of your minor children, both caring for their needs and managing their money. More complicated estate planning can also address tax issues and business planning. What is involved in estate planning? There are many issues to consider in creating an estate plan. Let's start by asking yourself the following questions. What are my assets and how much are they worth? Who do I want to receive those assets and when? Who should manage those assets if I cannot, either during my lifetime or after my death? Who should be responsible for taking care of my minor children if I become unable to care for them myself? Who would I want to manage their money? Who should make decisions on my behalf if I become unable to care for myself? What do I want done with my remains after I die? And where would I want them buried, scattered, or otherwise laid to rest? These are hard questions, and you may need help answering them. Once you have some answers or thoughts on these questions, you are ready to start some estate planning. Who needs estate planning? You do, whether your estate is large or small. Either way, you should name someone to manage your assets and make healthcare and personal care decisions for you if you ever become unable to do so for yourself. And an estate plan is how you do that. If you do not have an estate plan and cannot make your own choices, a judge will make the decision on who will handle your assets and personal care. And after you die, your assets will be distributed to your heirs according to a set of laws known as intestate succession. Contrary to what you may have heard, everything does not automatically go to the state if you die without a will. But what does happen will not be in your control and may not be how you would like it to go. The only way to change intestate succession is to do an estate plan. This is especially important if you would like your assets to go to non-relatives, like a partner you are not married to, friends, or charities. What happens if you become unable to care for yourself? Through estate planning, you can choose those who will care for you and your estate if you ever become unable to do so for yourself. Just make sure that your choices are documented in writing. A power of attorney is a legal document that gives another person the power to act on your behalf. Typically, it is so a person can manage your finances. In many cases, it is only effective when you become incapacitated. But what about your healthcare decisions? With an advance healthcare directive, you can choose someone to make healthcare decisions for you in the event you become unable to do so. In addition, this legal document can contain your wishes like a DNR or other healthcare issues and instructions concerning organ donation, disposition of remains, and your funeral. Many healthcare providers have form healthcare directives. At the very least, you could contact your healthcare provider for a form to complete on your own. If you become unable to make decisions or care for yourself, and you have not made any written arrangements in advance, a court could appoint a conservator to manage your finances and make your personal care and medical decisions. Having the court involved could be very expensive and could be avoided by having a power of attorney and a healthcare directive. What happens when you die? A will is a document that you can do to say who will be in charge of your assets and who will receive them. You can also nominate a guardian for a minor child in your will. A will is only effective on death and does not deal with incapacity. Depending on the value of your estate, when a person dies with a will, a court-supervised process called probate is needed. Unlike a will, a trust can deal with both incapacity and death. It can name a person to manage assets in trust if you become incapacitated, and it can also say where the assets go when you die. In most cases, trusts can avoid the need to go through the probate court process. Who should help you with your estate planning? Can you do an estate plan on your own? Yes, it is possible for a person to do their own estate planning if your situation is fairly simple. But if your situation is complicated or you have questions, you should contact a qualified estate planning attorney. You can ask friends and family that have done their estate planning for a referral, look on the internet for an estate planning attorney in your area, or call your local bar association for a referral. But please, make sure to use an experienced estate planning attorney. Thank you.